The Bleacher Report app is your destination for sports. Right now, the NBA's heating up, March Madness is here, and MLB is almost back. Every day there's a new headline, a new highlight, a new moment you've got to see for yourself. That's why I stay locked in with the Bleacher Report app. For me, it's about staying connected to my sports. I can follow the teams I care about, get real-time scores, breaking news, and highlights all in one place. Download the Bleacher Report app today so you never miss a moment.
Let's be completely honest. Are you happy with your job? The fact is, a huge number of people can't say yes to that. Too many of us are stuck in a job we've outgrown or one we never really wanted in the first place. But we stick it out and we give reasons like, what if the next move is worse? And I've put years into this place. And maybe the most common one, isn't everyone miserable at work? But there's a difference between reasons for staying and excuses for not leaving. It's time to get unstuck. It's time for Strawberry.me. They match you with a certified career coach who helps you get from where you are to where you want to be, either at your existing job or by helping you find a new one. Your coach helps clarify your goals, creates a plan, and keeps you accountable along the way. Go to strawberry.me/career and get 50% off your first coaching session. That's strawberry.me/career.
Hello, everyone, and welcome to Psych Legal Pop. This is not an emergency, but I guess a urgent.
Yes. Breaking news.
Breaking news, yeah.
We're here to bring you the news that you probably already know.
And if you don't understand that sound, you're a fresh young person.
Oh, that's right. A young person would have no idea what that
Okay, breaking news, guys. A mistrial was declared by the judge today in the Karen Reed trial.
Yes.
And so we're just coming on to talk about that and explain what this all means. If you've been following this case, we had our episode about what had happened so far prior to us recording came out last week. The jury deliberated for a total of 24 hours. And on Friday, this past Friday, which would have been June 28th, they sent a note to the judge and said, we're deadlocked. And the judge said, well, keep trying. And that's typical. That's what judges do. They encourage people to keep trying. And so they did. They went back and then they adjourned for the weekend. And then they came back today, Monday, July 1st. And shortly after they began deliberating again, they sent a note to the judge saying, we're still deadlocked. And she then read some instructions, which are called the Tui Rodriguez instructions. And that's named after a couple of cases, People versus Tui, People versus Rodriguez.
And can I ask a quick question? Is this Tui Rodriguez, is this state of Massachusetts thing, or is it across the country?
No, this is a Massachusetts thing. And in fact, I'm going to be talking throughout this about I found an article from a Northeastern University law professor, Daniel Medwed, and he says that these Tui Rodriguez instructions are controversial and outlawed in many states because of their possibly coercive effect. Because the jury's saying, look, we're deadlocked. We have this group of people who, they're not going to change their mind on both sides. And so if the judge then says, well, sorry, you got to keep going, it encourages people to cave. And fold and not go with their true feelings. So prior to giving these instructions, both sides had a chance to argue whether or not there should be a mistrial. And the DA was arguing that at that point, I guess they'd been deliberating maybe like 22 hours. And he was saying they hadn't deliberated long enough, considering there was 29 days of trial, 657 exhibits, and 74 witnesses.
Wow.
And the defense was saying, well, no. I mean, they're clear. This is now the second time they've sent a note saying, we're deadlocked. And if you just keep sending them back, like I said, it encourages somebody to just say, well, okay, I'm going to give in or whatever. So the judge gave the instructions, which basically say, look, you were picked to be the jury in this case. There's really no reason why another jury would be better suited to decide the case. There's no reason why either side would be able to offer a clearer case or more evidence in a retrial. And, please go back and try again.
So it's like a pep talk.
Yeah.
Like, you can do it. We believe in you, jury. So that's so interesting. So they're arguing back and forth about whether or not that those instructions should be read, but it doesn't sound like it is prejudicial, is it? I mean, it doesn't sound like it's, because it sounds like a big pep talk.
Right. But it's basically, I think psychologically, if you keep telling these people who, are very steadfast in their, like, I'm not going to change my mind.
Yeah.
And you basically tell them, well, you're not free to go until you get a unanimous decision.
Mm-hmm.
People start changing their minds.
Yeah, I guess you're right. Yeah.
Because they just want to go home. Yeah. And, they're saying, let's see, I'll read a couple of the excerpts. This jury note, this is the final note that they wrote to the judge. We continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges, which that right there means they're not debating like manslaughter versus murder.
Mm-hmm.
They're debating acquittal versus conviction of something.
That's what it's, yeah.
Yeah. So then the note continues, the deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. And after reading that, the judge said to the jury, I'm not going to do this to you. Your service is complete. I'm declaring a mistrial.
Okay. Well, they stood firm. I could see how, hearing that, I could see how the jury could feel pressured, like, listen, okay, I think she didn't do it, or I think I think this was a setup, but okay, fine, manslaughter. Like, let's pick, you know what I mean? Like the fear of splitting the difference between the two.
Right, exactly.
And it's still, if you do believe that Karen Reed is innocent, having a manslaughter charge is huge.
Yeah, or not
guilty.
Innocent.
I should say not guilty.
No proof beyond a reasonable doubt.
No proof. If you feel like there is enough doubt that it's not fair to then do this, right? Like, let's split the difference kind of thing.
Right.
But I see what you're saying, how that would be really easy for them to come back and go back and do that.
Yeah.
Yeah.
Yeah. No. Yeah. It would be like a compromise. Okay, we'll just do voluntary manslaughter, vehicular manslaughter.
Well, so do we have? I was looking, and I didn't see anything. But did you find anything about the breakdown of how many people were for acquittal, how many people were for conviction?
There weren't specific numbers, but the foreperson used the language. Saying that our perspectives on the evidence are starkly divided. So I think it was probably kind of split down the middle, as it has been throughout this entire case. It's divided the town. It's divided.
Yeah.
You see the Karen Reed supporters out there. You see the anti-Karen Reed people. So I imagine it's pretty evenly split.
Mm-hmm.
But who knows? I was watching some news clips. There was some alternate juror who gave an interview, not on camera, but an interview to a reporter in Boston. And this juror said that she was disappointed. She believes the Commonwealth didn't do their job. And she said that regarding Proctor, even if he wasn't a part of this case, the state still didn't prove their case.
Interesting.
Yeah. So, yeah. So what else did this expert was saying that he's saying that, okay, so let me back up. So after the mistrial, of course, both sides make an announcement. Now, a lot of times in trials where this happens, there's a mistrial. The prosecution does not immediately announce, well, we're going to retry the case. They don't say anything. They go back to their drawing board and they discuss it internally and they decide as an office, because ultimately it's up to the head DA or prosecutor in the county. They make a decision. Are we going to retry this case or not? But they came out right away today and said, we are retrying this case. And that's kind of unusual. And then Karen Reed and her lawyers appeared on the courtroom steps, and the defense attorneys are like, we're not quitting. We don't quit. We are continuing to defend Karen Reed.
Yeah.
So there's a lot of posturing, but this expert is saying that it's an uphill battle for the prosecution, that a retrial is likely going to require new evidence because the evidence that you presented didn't cut it.
Yeah.
Didn't do the job.
Yeah. I mean, I think that so much of this is, and I don't know what this expert is saying, but it feels like the line down the middle is really about whether or not you believe the police could do something like this, that people, police officers or people that have that kind of power, or that people in general could get together, collude, and lie.
Or even, not even a police cover-up. Let's just say we take out the police cover-up altogether. And you just look at the physical evidence of his injuries, of her behavior, of other people's behavior, whatever was said. There really wasn't evidence that he was struck by a car. And that was some of the very final testimony in the trial of the medical examiner, saying that the injuries were not consistent with being struck by a vehicle. So it's, even at its core, there's some issues with it.
Yeah. I'm just talking about like big picture of what, they're saying philosophically we're divided. And I would think that means that there's one side that feels like people can lie, people can collude, this can happen, even people that say they're going to serve and protect. There are those group, and that's group. And then it feels like there's this other group that feels like, no, the law is the law. This all seems to line up. This all lines up. This all makes sense. And, I believe the police, or I believe authority. I believe when this happens. That's what it feels like to me. That feels like the dividing line. I could be wrong.
Yeah. Like whether you believe that this many people would conspire to cover this up or not.
Yeah. And I think that maybe if this trial was 20 years ago, I don't think so many people would be able to say I could see cops doing this. I think that the events of the last 30 years have not helped.
Well, yeah, and look at all these crime documentaries.
Yes.
Stuff that we watch where you see. So there's evidence. I mean, there's a certain group of people in the population who know very well that this stuff happens because it happens to them, people that they know. But then there's another group that they don't have this kind of contact with the police. Yeah,
none. They've only had, positive interactions. No one's ever lied, or their family members, and they wouldn't lie. And I think it's a shame too, because there's so many police. There are a lot of police officers out there that are doing a great job and doing it well. It's just usually the big documentaries aren't about them.
Right.
When you're just trucking along, doing your thing, we don't see that so much. But yeah, I do. I think it's this people that can believe that question authority and believe that you could be lied to, and people would get together and collude. Because I think a lot of people can't believe that a whole group of people would lie, but like that people will collude. And then there's the other side that has never had a problem like this, or they have this one way of seeing the world that are Like, no, she was in the car, even though this person came on in this last, the examiner came on and said his injuries didn't match up. I think even though people hear that, they still feel like, well, there's no such thing as a coincidence. She's the last one with them.
Right.
Doesn't that make sense that she would be the one? She was intoxicated. She could have easily hit him, and that's it.
But was she the last one who saw him?
Yeah, well, that's what I'm saying.
Yeah. There's a lot of, ultimately the prosecution could not prove what happened.
Mm-hmm.
It was a lot of speculation. There was very weak, very, very weak physical evidence. And it was speculation. It was a theory. And, this is supposed to be guilt beyond a reasonable doubt. And, it has to be unanimous. And that's why, I don't know, the idea of this retrial thing kind of bugs me because, if that many jurors who heard all the evidence think that there was not guilt beyond a reasonable doubt, then there's obviously serious issues with the evidence in the case. And it seems borderline unethical for the prosecution to keep getting another bite at the apple, because giving them time to hone their case or something. But like this professor was saying, it's going to be difficult because if you go and retry the same case with the same evidence and you can't come up with anything more compelling in the same community with the same people who have already they've already seen all this. Like how fair is that this entire community has already watched this trial and seen all this stuff?
Yes.
It just seems really highly prejudicial to me.
Yeah. How are you going to find 12 jurors?
Yeah.
Again.
Because this thing was televised on court TV.
Yeah. Yeah. No, I am with you because I have always often thought about that. I always thought it was weird that if they don't all agree, then it becomes a mistrial, right? But because that's what everyone always says, you just need one holdout. You just need one person to question things. But it's like, well, no, you need more than one person to question things. You need one person maybe to create a retrial. But it just, what I'm trying to say is that, yes, if the prosecution's burden is to show us beyond a reasonable doubt that Karen Reed did this, and if you have at least, and it sounds like it's not just one holdout. My guess, I feel like it's probably 5 or 6 each way, right? So if you've got 6 people that are holding out saying, no, I don't believe that, then that is reasonable. Isn't that reasonable doubt? But it's so weird that each person on the jury has to have the same reasonable doubt. Yeah, that is interesting.
Yeah, it's very hard. Because, of course, all criminal verdicts have to be unanimous. And so if it's a mistrial, the defendant is not convicted, but they're also not acquitted.
Yeah.
They still can be retried. And the only way to be acquitted is with a not guilty verdict by 12 people. Yeah. And that cannot be appealed, cannot be overturned. Nothing's,
Yeah.
Like O.J. Simpson could have come out on his deathbed and said, I did it. And, he could never be touched, ever again. So, it's a little weird. But
well, let's see what happens. Yeah. And the other thing, too, is, the prosecution, they can decide not to prosecute, but we'll keep this in our back pocket, and then this woman is living for every day wondering, am I going to get, are they going to come back around and find new evidence and then nail me now?
That's a good point. Because there is no statute of limitations for murder. So they could just say, okay, well, we're going to wait. We're just going to wait until some better evidence comes along.
Yeah. But people forget about the case.
Someone comes forward. Yeah, exactly. You're right. They can hold it in their back pocket and wait and see what happens. And they can always file new charges later.
Which really isn't particularly fair. I noticed that apparently Karen Reed went out over the weekend, to dinner. Someone took a snapshot of her and there was all this criticism. And I was thinking to myself, if I thought I was going to go to prison for however long, I think I'd be going out to dinner too. I
Well,
mean,
also, what is she supposed to do? I mean, she's allowed to go out to dinner.
yeah, I mean, I think it's this weird thing. People feel like, oh, she should be hanging her head in shame. And
Mhm.
it's a little bit of like, okay, but
She
you
says
know,
she's innocent.
she says she's innocent. She has the right to go to dinner and eat. And I too, if I thought I was going to be convicted, falsely convicted of something, I think I would be getting as much good food in me as I could, and going out and having experiences and such. So it just feels like she just can't win.
That just shows you the pettiness of all of of all of it. Like,
Mhm.
these are people, And another thing, I have to say, I watched a clip of, the moment when the judge declared the mistrial. The camera, of course, immediately panned to John O'Keefe's mother. And I think I realized in all of this, we've really forgotten this guy died.
Yeah.
Yeah. No matter how he died, he died.
Yes.
We don't hear a lot about him in this trial that isn't negative.
Mhm.
But he has a mother, he has a family. They pan to his mother, who's just sort of kind of quietly crying.
Yeah.
And visibly just looked kind of hunched over and defeated. And it was like, oh my God,
Yeah.
this is, he has a family. There are other family members there sitting with her.
Well, and he was raising his niece and nephew, right? Which means that his sister passed away.
Right.
Right. So here's this mom, two children.
Two children, right.
Two children you've lost in a pretty short amount of time, too.
Yeah.
Yeah. Yeah. I mean, and that's the thing in all of these cases, right? There's no closure. No one's a winner. No one's anything.
Mm-mm.
And it's usually the victim that gets lost in all of this because, yeah, you're right. He did die. And that mother had to bury her son.
Yeah. And the weird thing about the configuration of the courtroom, too, is that, it's very small and there's this kind of little gallery of like a spectator gallery. I don't know how you get tickets to that. It's a very few seats.
Mm-hmm.
And so, John O'Keefe's family is there. And then next to them is Karen Reed's family. These people are all sitting very close together.
Yeah.
And then next to them are all the other people, Brian, God, I'm already forgetting his last name.
McCabe?
The house where it had Albert. Like you've got the Albert family, you've got other people. Brian Albert was not there when the mistrial was declared, but I've seen other footage of him, in the courtroom in that little gallery he was watching the closing arguments. And I think Karen McCabe is that, there's that whole contingency. And all these people are sitting right next to each other, just 3 feet from Karen Reed.
Yeah.
Where she's sitting at the defense table with her. And she's like, God, talk about awkward.
Yeah. Yeah. No, very awkward.
Very awkward.
Very, very awkward for everybody.
Yeah.
Wow. Was there anything else to report?
Oh, not that I can think of. That's,
all right. You think they'll move or does that not matter at this point? I mean, where they moved from Canton to Denham wasn't that, as we talked about, wasn't that far away. But do you think they'll move to like Western Mass or I don't know. I mean, I assume they have to stay in the state. The state's not that big. Do you think they'll move or is it like, well, what does it matter? It's like switching deck chairs on the Titanic. It's just moving to Western Mass doesn't mean that you're going to get 12 people that hadn't heard about the case. Yeah.
I mean, maybe the farther you could get away from Boston and these communities where these witnesses live, like where Proctor lives and where all these, the Alberts and whoever, maybe. But I don't know. At this point, the whole change of venue thing, I just feel is kind of ridiculous in this day and age. Mm-hmm. Even when they did it for like the Scott Peterson case or the Rodney King case, I think they moved the venue. I mean, we have televisions.
Yeah. Well, moving venues definitely helped OJ.
Well, that was the civil trial. So because what happened was he was okay. So the murder took place in Los Angeles County, and normally the trial would take place in the the county, Los Angeles County is huge.
Mm-hmm.
More people live in Los Angeles County than 40 states in the United
Wow.
States. It's ginormous. So there are courthouses all over the place. So, like, technically, the murder happened in Brentwood. Technically, the trial should happen at the Brentwood courthouse, but it's a small courthouse, and the prosecution wanted to have it in the main courthouse downtown where they are located and operate out of, because it would be more convenient for them. And that
so they made that point. Okay. I thought
so
okay.
They didn't want to change venue. I shouldn't say that. They filed it in that main courthouse and the defense didn't object. They're like, great. Okay. Thank you. That's what probably won the case, right? So now we're in a venue where there are people of color, totally different than all white Brentwood where Nicole lived. So that was that. But when the civil case was filed, it was filed in Brentwood. It was in that community. And also civil case, you only have to have 9 out of 12. You don't have to have 12 out of 12.
Yeah. Okay.
So kind of different. But like the Scott Peterson case, when they moved it from, Stanislaus County to whatever the county was.
Did they move it to closer to us?
It was like I want to say Santa Clara.
Oh, then that's down
San
south.
Mateo, Santa Clara
County.
No, they were out in like Stanislaus County.
Yeah, because they were Stockton.
So that's not that far, but I mean, it doesn't really matter. We're all watching this case. It's a big Bay Area, Greater Bay Area. It was a national case.
Yeah,
I don't think you could have.
So I guess changing venues is not going to be up for that. But yeah, I mean, yeah. So we'll see what happens. But if there's let's say they go through this again, there's another mistrial. I know that the prosecution could bring it up again, but do you think they will? Do you have any sense?
Well, I would hope not. I would hope by that point, number one, this is costing the county a lot of money.
Oh, yeah.
That they don't have. Okay. So this trial, I'm sure, cost this county over $1 million. This is taxpayer money.
Yeah.
What is the point? Is vengeance the goal?
It's a good point. Yeah.
So,
I mean, and all of this is political, right? These are right. The district attorney is an elected office, right? I mean, he or she's got to think about,
right.
How is this going to look? So I'm curious to see if they would try a third time, just because, will it start to backfire?
Well, I'm curious to see if they'll even try it a second time, because like I said, they're talking all tough today, so ultimately, they still have to make a decision. Are we going to spend this kind of money? We're going to put the residents through this. We're going to put another jury through this,
My guess would be, right, that the decision, maybe the prosecution's decision, will really be based on interviewing the jurors and finding out exactly, how far away were we from a conviction. I mean, that's what I would do personally. I would assess the jury. If the jury would be willing to talk to me, I would assess as much as I could to get a sense of where's everybody out. And can I make a case for, right? If I change some things around, would I get the conviction or not?
If the jurors will talk to them. And the thing is, the jurors that are more likely willing to talk to them are going to be the ones who agreed with them. They really need to talk to the people who did not think they met their burden of proof. And those people might not want to talk to them and help them. Yeah,
that's true. That is true. Or maybe they'll help the other side.
Yeah.
Anyway.
We'll see.
So,
all right.
Well, yeah.
That was that.
Okay. All right. Thank you so much, everybody. And we'll be back tomorrow with Sister Wives. Just trucking along here.
Yeah, life goes
All right.
on.
Yes. All right. Bye.
This message comes from Jackson. Taxes aren't something you can only think about once a year. With investments, planning for tax day is year-round. Fortunately, Jackson offers tax-efficient products. Visit Jackson.com for more information on how our products can make your tax bill a little bit less painful. Jackson is short for Jackson Financial Incorporated, Jackson National Life Insurance Company, Lansing, Michigan, and Jackson National Life Insurance Company of New York, Purchase, New York.